Okay, Fourth Amendment. Hi, I'm host Eric, who's talking with famous people, and I'm here with my awesome Walnut Squad. We're talking about the new public forum topic, and it is about applying the probable cause standard for students in schools. So before we even get into that topic directly, we need to talk about the Fourth Amendment. Fourth Amendment reads, "The right of the people to be secure in their persons, papers, and effects against unreasonable searches and seizures shall not be violated. No warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or particulars to be seized." Alright, so this is, if you take it at its literal word, says the cops can't search you unless they have a warrant. And if they do have a warrant, it has to be supported, has to be issued based on probable cause that the thing that they're trying to find is there, supported by oath or affirmation, so it's got to have an affidavit of some sort, and particularly describing the places to be searched and the persons or particulars to be seized. So, the first clause here is this. It says the right, remember, a right confers a duty on another. A duty of non-interference. So you have a duty to not search people against their will. Unless what? Well, the right of the people to be secure, unsearched in their persons, papers, and effects. That's your little stuff, your glasses and whatever else you got around. Against unreasonable searches and seizures. Against unreasonable searches and seizures shall not be violated. Well, this does tend to suggest, this adjective here, that there is a reasonable search or seizure that would not violate their rights. But note here, the way that we protect against unreasonable searches, according to the Fourth Amendment, how do we know if it's reasonable? The same way we do in debate. Is it warranted? What is a warrant? A search warrant. Well, it's the same thing as a warrant in debate. In debate, a warrant is a reason why your argument is true. In law, it's a judicial authorization for police searching. And the judicial authorization makes it warranted. It has a reason. The cops have a reason to be searching me now. Why? Because a judge signed off on it. Somebody went to court and said, we need to search Eric. We think he has a nuclear bomb in his pants. And the cops come to my house and they said, take off your pants, Eric. And I said, no, I'm taking off my pants. They said, we think you have a nuclear bomb in your pants. And I said, well, cops, I don't care if you think I have a nuclear bomb in my pants or not. You don't have a warrant. And they say, oh, yes, we do. Then I take off my pants. I say, see, no nuclear weapon. Our bad. No warrant shall issue but upon probable cause. That's why, what's the cause of the warrant? Right? The judge can't issue a warrant except upon probable cause. What made that judge think I had a nuclear weapon in my pants? Oh, you mean it came to him in a dream last night? Is that a good enough reason to issue a warrant? Probable cause is not a dream because it has to also be supported by oath or affirmation, and particularly describing the places to be searched and the persons or particulars to be seized. So this clause here is all about how to warrant a search. How to warrant. to make reasonable. Alright, so this probable cause standard then, you might think, oh, we're arguing about whether students, if I'm going to get a warrant to search your locker, should I have to have probable cause when issuing that warrant? In other words, is it okay for a judge right now to issue a warrant to search my locker where he says, the reason I think you have a nuclear bomb in your locker is because it came to me in a dream? Well, according to this, it has to be probable cause supported by oath or affirmation. So that wouldn't work. That's not what we're actually arguing about. We are not arguing about whether or not warrants to search students need to be supported by probable cause, because the Supreme Court has chosen to interpret this piece of text in a very strange way. Now, the Supreme Court says if a cop pulls you over and he has probable cause to search you, then that's okay. So let's say a cop pulls you over and you're driving and he smells marijuana in your car. Well, now he has probable cause to search you. Are you secure in your person's papers and effects against unreasonable searches and seizures and have that right not violated, and no warrant shall issue but upon probable cause? Is that what's happening there? Is the cop obeying the Fourth Amendment? If a cop smells marijuana smoke in your car and he says, now I have cause to search you, is that following the Fourth Amendment? Well, to whom did he give oath or affirmation? I mean, the thing is, if I'm a cop and I say I smell marijuana smoke, then the ability for me to be secure in my papers, persons, and effects is reliant entirely on a police officer's willingness to make that lie in a moment. Now, to me, that's not supported by oath or affirmation at all. That's not a warrant at all. That's an unwarranted search, because a warrant is issued by a judge. But the Supreme Court hasn't ruled it that way. The Supreme Court has eviscerated the Fourth Amendment so that basically if a police officer can claim he has probable cause to search you, he can search you whenever he wants. That's how it's interpreted now. If a police officer can claim, write it down, if a police officer can claim that he has probable cause to search you, then he can search you legally. And you have to sit there and take it. Additionally, there's something known as the Terry pat-down. There was a case, a Supreme Court case, with a gentleman named something Terry. Terry was the last name. And the cops searched him for a gun. They patted him down for a gun, and they found one and arrested him. And they said, well, that's an illegal search. You had no probable cause to search me. And then the Supreme Court said, well, it's okay. It's reasonable for cops, if they pull you over for their own safety, to at least pat you down and make sure you don't have a gun. So now that's okay, without any cause whatsoever, not even probable cause. So the Fourth Amendment applies mostly in your house. The Supreme Court has been pretty good about protecting the rights of the home against invasive illegal searches. In general, the Supreme Court has said to go search your house, the cops do have to have a warrant. Now, note this as well, though. Even when things are warranted, it doesn't necessarily mean that you're going to have a good search. And the reason is because the probable cause issue, even when applied properly, is an inadequate mechanism to protect people against illegal searches. I will tell you the story of David Eckert. David Eckert was a gentleman who was driving in New Mexico, and he was pulled over by the police officers. Pulled over for something like failing to signal a turn. Okay, something stupid. And they got him out of the car, and they said, why are you clenching your butt cheeks? And he said, I'm not, I'm just standing here. and the cops said, "You have drugs in your butt." And they took this evidence of theirs, evidence that he was clenching his butt cheeks, to the district attorney. The district attorney took it to a judge. The judge signed a warrant saying, yeah, you may use forced invasive medical procedures to search him for drugs. That proceeded to take him to a hospital. The first hospital refused to do it on moral grounds. The second hospital said, okay, well, you got a warrant, I guess we'll do it. And they did x-rays, CAT scans, and, like put a glove on, reach up his butt, and give him enemas, which are things that flush out all your poop, for like 10 hours straight. There weren't any drugs. Now, the question is, well, that was a legal search. Yes, it was a legal search. Who's accountable? Is it the cops for saying that clenching butt cheeks is evidence enough to justify 10 hours of invasive medical procedures? Is it the attorney general who thought that the fact that the cops said he clenched his butt cheeks was good enough reason to take this to a judge? Was it the judge who signed off on this on the grounds that he seemed nervous and clenched his butt cheeks? That was good enough reason to justify hours and hours of invasive medical procedures? Who is accountable? Who? People who had nothing to do with it. Taxpayers. Of course, he won a lawsuit, won millions of dollars. The cops are still on the job. The attorney's still on the job. The judge is still on the job. Why? Why? They cost us millions of dollars with their stupidity. Why wouldn't they get fired? For anything that's not a public job, you'd be immediately fired. Of course you would. Who would tolerate an employee who loses your company millions and millions of dollars? Nobody. So that's the system we have now. Why? Because the Supreme Court does not take this seriously. They do not look at these words and take them for what they mean and they say. And they don't like the fact that that would mean that cops can't search you, even if your car smells like weed. You're driving around, they pull you over, a big cloud of weed smoke comes out of the car. They have to let you go. And then, if they really want to search you, they have to go get a warrant and search you that way. The Supreme Court said, we cannot possibly conceive of that world being okay. So, let's make exceptions. But the world that they conceive of being okay instead is a world where Dennis Eckert gets his butt searched. It's a world where black people get shot when they get pulled over for no reason because cops feel entitled to fuck with people. That's the only reason, right? Why do they feel entitled? Because of this ridiculous thing, the probable cause standard. When they are asking you, should the police have to have a probable cause standard to search students in school or school administrators, they're saying this incredibly ridiculous thing. Should authority figures have to give some kind of reason to search you rather than no kind of reason at all? They're not saying anything about getting a warrant. That's not what probable cause means anymore. So, should your school principal have to have a good reason to search you? Yeah. Are you human beings? Yeah. Should you tell your principal to go fuck himself if he doesn't treat you like that? Yeah. Of course you should. But we're going to negate this resolution by saying probable cause standard is way too weak. We need to apply the actual Fourth Amendment to students. That's a good way to negate it. You say, if we apply the probable cause standard, we are immediately affirming the Supreme Court's false, deceptive, lying, bullshit, and harmful interpretation of the Fourth Amendment that eviscerates all the protections that afford the individual human being living in this country from invasive government searches and seizures. We know what happens when we do not respect the Fourth Amendment. We know about property seizures and drug war. We know how unjust those are. We know about illegal searches of black people in cars. We know how unjust that is. This probable cause standard is inadequate. It creates injustice. It does not protect us from it. That's why we argue against it. That's how we argue against it. We argue more libertarian on both sides. On the AF side, we're going to argue, well, it betters rights, even if it doesn't solve the situation, it at least betters the situation. But on the neg, you say that's not adequate. It doesn't better the situation because when we embrace this option, we necessarily preclude the others. Hi. Welcome. Come on in.
We have new parents here.
Great. Well, listen, this is not a class. This is just, come on in. This is a drop-in session. Hi.
Julie.
What grade are you?
Seventh grade. Seventh grade.
Excellent. Perfect.
Excellent.
That's the perfect grade.
Yeah.
So right now what we're doing is we are talking about, sit next to Grace. Okay? Right now what we're talking about is the Fourth Amendment, constitutionality and stuff. But we're, like I was telling the students, this is not actually a class session today. This is sort of a preseason drop-in time. The parents dropped in, they asked their questions, and then they're like, okay, we'll be back at 7, and left all their kids here, which is fine, but that's not really what was intended. So don't feel like you're interrupting anything. Anyway, that's the thing about the Fourth Amendment and the angle we're going to take on that.